Rule 56 of the Federal Rules of Civil Procedure governs the entry of summary judgment in federal court. Prior to the 2010 amendment, Rule 56C provided that a party would be granted summary judgment if the pleadings, depositions, answers to interrogatories, and admissions on file, together with the affidavits, if any, show that there is no genuine issue as to any material fact, and that the moving party is entitled to a judgment as a matter of law. In Celotex Corporation v. Catrett, Myrtle Catrett brought a wrongful death action on behalf of her husband against Celotex and over a dozen other asbestos manufacturers in federal court in Washington, D.C. Myrtle claimed exposure to these manufacturers' asbestos caused her husband to die from an asbestos-related illness. Celotex moved for summary judgment, arguing that Catrett hadn't produced any evidence linking Celotex products to the death of Catrett's husband. However, when making its motion, Celotex did not provide any evidence to show that its products hadn't caused the death either. In opposition to Celotex's motion, Catrett submitted 3 documents that she claimed demonstrated a genuine material factual dispute about whether exposure to Celotex's products had caused her husband's death. Celotex objected that the documents were inadmissible hearsay and couldn't be considered. The district court granted Celotex's motion for summary judgment, even though Celotex had not provided affidavits or other evidence to support its motion, because it concluded that Catrett had not met her burden of showing that her husband had been exposed to Celotex's product. On appeal, the parties disputed what the burden of proof was and on whom it rested on a motion for summary judgment under Rule 56. Celotex argued that to defeat a summary judgment motion, the burden should be on the non-moving party, which in this case would be Catrett, to show, based on some affirmative evidence like affidavits, that there is a genuine issue of material fact for trial. Catrett argued that summary judgment was improper because Celotex didn't support its motion with affirmative evidence. The appellate court ruled in Catrett's favor, holding that in a Rule 56 motion for summary judgment, the burden is on the moving party to prove an absence of any genuine issue of material fact by affirmative evidence. Celotex petitioned the United States Supreme Court for certiorari. Justice Rehnquist, writing for the majority, held that the party moving for summary judgment is not required to provide affirmative evidence of an absence of material facts in dispute in order to prevail. Rehnquist found that the lower court erroneously read Rule 56 to require Celotex to provide evidence disproving Catrett's claim, when in fact Celotex could have been granted summary judgment just by pointing out to the district court the absence of evidence to support Catrett's claim. The court remanded the matter for consideration of whether Catrett had shown that there was no material facts in dispute. Justice White concurred, noting that the party moving for summary judgment must provide evidentiary support for the motion that goes beyond mere allegations, such as by reference to depositions and answers to interrogatories, showing that the plaintiff has no evidence to prove her case. Justice Brennan dissented, finding the court's legal analysis correct, but finding fault with the application to the facts of the case. Brennan's analysis was based on who has the burden of persuasion on the issue at trial. For example, a plaintiff moving for summary judgment would have to give credible evidence that, if not disproved, would entitle him to a directed verdict. A defendant moving for summary judgment would have to offer affirmative evidence or show that the plaintiff's evidence is insufficient to establish an essential element of the claim. Here, Brennan found that Celotex failed to meet its burden. The Celotex case had a massive impact on federal litigation and greatly expanded the availability of summary judgment for disposing of cases. Under Celotex, a defendant could be granted summary judgment just by showing that the plaintiff hadn't produced evidence of some essential element of her claim, even without offering any affirmative evidence. Celotex, along with Anderson v. Liberty Lobby and Matsushita Electric Industries Company v. Zenith Radio Corporation, set forth the substantive standards governing Rule 56 summary judgments. These cases are collectively referred to as the 1986 Trilogy and are among the Supreme Court's most cited cases by federal courts. Rule 56 was amended in 2010, but the advisory committee notes make clear that the changes did not alter the standards laid out in the Trilogy. If you found this video helpful, You can explore all of our content by visiting us at Quimbee.com. If you have a question or comment about this case, please post it in the comments area below, and we'll do our best to get back to you. If you think we did a good job with this video, please like, share, and favorite it. And if you think this video might be helpful to people you know, please share on social media, Facebook, Twitter, and Google+ as well, to get this video out there. If you haven't done so already and you enjoy watching videos on this channel, click on the red subscribe button just below this video so you can get all the latest updates.